23156. All right, we are back on record in this case, getting ready to proceed towards trial. So we're looking for any other motions. This is our final pretrial. May I have the names of our participants, please?
Good afternoon, Your Honor. Ariel Berger here as the guardian ad litem for the minor children.
Nastasia Thomas, counsel for the department, and present is Miss Nikki Jones, who is the CPS investigator, and Miss Chelsea Grant, who is the ongoing caseworker. Miss Jones, will you please put your appearance on the record, followed by Miss Grant.
Nikki Jones, CPS investigator for the Department of Health and Human Services.
Chelsea Grant with the Department of Health and Human Services for the ongoing worker.
Good afternoon, Judge. Alex Lizahub appearing on behalf of the respondent, who also is appearing by Zoom.
Mr. Higgins, would you be so kind as to introduce yourself for the record, please?
Yes, and Matthew Virgil Higgins Jr.
Very good. All right, one of the issues that's been adjourned to today is the issue of the intent to use alternative procedures. I did receive a response. Do we want to take that up first?
Sure, Judge.
Okay, Ms. Thomas, why don't we start with you on your position, then we'll let Mr. Elizabeth respond.
Thank you, Your Honor. As it relates to the motion, in it, I have cited the court report that was submitted for admission. Wow, that is not correct. It was submitted in anticipation that we would have testimony on it at the last or at a prior pretrial in January. So I'm not sure if at this time it's appropriate to take that testimony from Ms. Grant to admit to the court report, but I am happy to move forward on my motion regardless at this time.
All right, it sounds like we may need some testimony on it. So, Mr. Elizabeth, did you have any comments before we turn to testimony?
No, Your Honor, I've stated our position in the response, and for the court to hear evidence and make specific findings. And to the extent the court finds that, then obviously the court has the jurisdiction to allow those alternative means. So I did state everything. I know, just as a comment, Judge, I know sister counsel said video conferencing, but Your Honor discussed that the respondent could leave the courtroom during the testimony of the child witness. And I believe that would be better logistically and better for the jury to be able to determine the credibility of the witness, to see the person directly as opposed to by camera. I only say this, Judge, if you do determine that alternative means are necessary, I would request that my client be able to view those proceedings contemporaneously, and that I be able to contemporaneously be able to communicate with my client, attorney-client privileged during those proceedings, and that the children likewise be advised that their father is also viewing the proceedings.
Any initial comments, Ms. Berger?
I am in support of the request for the, I guess, the plan for testimony of the minor children. I was hoping we could do something where they could connect virtually and dad could stay in the courtroom, but if that is not possible, then I would be in agreement. Thank you.
All right, witness testimony, Ms. Thomas.
Thank you. Ms. Grant can please be sworn in.
Deputy Ames, swear in Ms. Chelsea Grant.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Ms. Grant, can you please state your, again, for the record, can you please state your role in this matter?
My name is Chelsea Grant, and I am the ongoing worker for the family.
And as the ongoing worker, did you prepare a court report that was submitted on or about January 2nd of 2024?
I did.
And what was the purpose of that court report?
There was a review hearing at that time, so I completed the court report for the review as well as supplying all of the requested documentations, including trauma assessments that were completed, counseling updates from the referrals that were made.
And since you've submitted this court report, have you circulated any further documentation regarding these children?
I have not at this time.
Are there any updates or modifications that you're aware of that need to be made to your court report or any of the attachments?
At the time, no. We are in the process of the counseling right now. The contract is ending for the 12 sessions with the recommendations from the current counselor coming in with what that would look like for future, either renewing the recommendations for the counseling or exploring new counselors.
We're going to hold that thought because I think that it's going to tie into a little bit about the motion as well. But as it relates to your initial court report, generally, how would you say the children are doing?
They have adjusted to being in mom's home. Each one has a different, obviously, level of understanding about what had happened and what brought them here, each based upon their own experiences. Overall, at mom's house, they seem to enjoy their placement. They do miss old friends, activities, those types of things, but the home environment itself, needs being met, things are going well.
And have you met with the children personally?
I have.
And during your meeting with the children, have you been able to discuss their right to participate in these court proceedings?
I have.
And what is their opinion on that?
Your Honor, I'd object as hearsay.
They're parties, Judge.
Well, now also the rules of evidence don't apply in these proceedings, only as it relates to adjudication.
Thank you. I would concur. So for both of those reasons, the objection is overruled, but duly noted for the record. You may answer the question.
So two of the youngest, the two L's, do not wish to participate in any of the hearings. The two oldest, who are both MH. So the male and female have both stated that they do wish to like observe, understand what's going on, maybe not necessarily participate, but they do have a lot of anxiety about like upcoming courts and trials and want to know like how it works, who would be there, who would be where.
In your report, you indicate that the subject minor who is the alleged victim in this matter had a lot of questions for you regarding that process. Is that fair to say?
That is.
Okay. And included in your court report on the last page, there is a letter from a therapist. The therapist is treating or working with the family. Is that correct?
That is correct.
So Miss Elliott, have you had the opportunity to speak with her about the children's progress and their goals of treatment?
Several times, yes.
I would object as the hearsay.
Mr. Lizzie, this is a pretrial review. The rules of evidence don't apply other than at adjudication. So what is the purpose of your continued objections?
Well, my understanding, Your Honor, was that the court itself was to interview the children to determine the need for alternative procedures.
That's not okay. So let me try. Why are you continuing to object on the basis of hearsay? Do you contest that the rules of evidence should apply to this particular proceeding? Help me understand why you continue to raise that objection.
Well, I'm making a record, Judge, and I understand that the rules of evidence don't necessarily apply to these type of procedures, but I still want to make my objection.
Okay, well, the objection is denied, and just understand that, we need to get through this hearing this afternoon. So if it's unduly delayed by objections that you understand do not apply, that's not gonna go over well this afternoon. Let's just put it that way.
Thank you, Judge.
Very good. You may answer the question.
Can you repeat the question? I'm sorry.
Yes. Have you had the opportunity to speak with Miss Elliott?
Yes,
And you, in your prior testimony, you stated several times, is that accurate?
that is accurate.
And in your conversations with Miss Elliott, do her concerns or noticings in professional opinion match that of the letter that she wrote and provided dated December 30th, 2023?
They do.
And specifically that the two older kiddos, M and M, have had conversation about testifying in front of this court, that there's anxiety around it, that they do not wish to see well, I suppose this is just for the female, that she does not wish to see her dad in person, nor the family members who would be there to support her. Is that accurate?
That remains accurate, yes.
And is that, has that child also said the same thing to you?
Yes. The only difference is she had stated that she would be willing to testify. She just really does wish not to see dad or any supportive family members of dad.
You mentioned in your earlier testimony that the referral for counseling was essentially closing out, right? That's referred for 12 sessions and then it needs to be renewed. Where does that stand as of today?
So the two youngest, sorry, I had to make sure I didn't say their names. The two youngest males just finished up their sessions, I want to say about 2.5, 3 weeks ago, along with the two oldest the week prior. All the boys had successfully met their goals that they had during sessions. However, there was a recommendation for the minor female to transition to a trauma-based therapist to talk about the concerns related around what brought her into care and what removed her from her dad's care. She will talk a little bit about it, but the emotions become overwhelming for her to talk about it. And this in-home therapist believes she would be more beneficial with a trauma specialist compared to what she is able to offer in home.
Did you review the trauma assessments that are included in your court report?
I did.
And do any of the trauma assessments for the youth indicate that there is, in fact, post-traumatic stress disorder diagnosis, or the criteria cannot be ruled out?
Yes. I can't remember specifically. I believe at least two of the boys do have that.
And that was also true for the female, correct?
That is possible. I would have to review it. I'm sorry.
It's met several weeks ago. Thank you. As it relates to the trauma assessments, have you been able to make any referrals for the recommendations that are included on those?
We have begun working on them. So the therapist looked over each and every one of the children's trauma assessments and identified those with her strengths and needs in her ongoing treatment, and if she would recommend moving forward with their services or not, or recommend, moving forward with their services or not based upon those. I know Ms. Higgins has also worked on IEPs and getting those reestablished. They needed to be renewed from the onset. And that's kind of where that has been. We got the referrals just before Christmas, and then we have been working on, meeting the first needs of counseling first, and then moving towards the academic needs.
there anything else you'd like to bring to the board's attention from your court report or the trauma assessments, or any of your knowledge is for purposes of review?
Not at this time.
Your Honor, at this time, I would move to admit the court report that was submitted in early January with
No objection.
No objection, Your Honor.
All right, the court report and the exhibits?
yes, Judge.
All right, so I heard the court report, but not the exhibits bit. Is there any objection to the attachments?
No.
No, Your Honor.
Thank you, they are admitted. Cross-examination, Mr. Lizahu?
None, Your Honor.
Ms. Berger?
No, thank you, Judge.
Very well. Any other witnesses for purposes of our pretrial review then, Ms. Thomas?
No, Your Honor.
Very good. Well, Mr. Lizahu, just to confirm, did you want me to hear from anyone for purposes of the pretrial review?
No, Your Honor.
Ms. Berger?
No, Your Honor, thank you.
Very well. Okay. Do you want to go back to the other issue, Ms. Thomas? Do you want me to make a ruling on the pretrial review aspect? What's your preference?
I would, at this time, just offer a brief argument on the motion for an alternative measures.
Go ahead.
Thank you, Your Honor. The Court of Appeals has repeatedly stated, and specifically in Ray Brock, that the respondents' Sixth Amendment rights to confrontation do not apply in child protective proceedings. Although that is true, we are asking, and we do not wish to violate any of Mr. Higgins' rights whatsoever, but we are asking this court to utilize its broad authority as relates to providing these witnesses that may be called with protective measures so that they may be protected from further trauma. Specifically, if no one else, we are asking that the alleged victim in this matter be allowed to testify outside of the view of Mr. Higgins. We have no objections to that testimony being obtained through a one-way closed circuit, which is what most of the resources that I've been able to find in case law and statute provide. And as this court mentioned also there at the last hearing, that there could be a possibility where Mr. Higgins is outside of the courtroom, but able to watch the proceedings contemporaneously and have instant access to his attorney. Both are agreeable to the department. The main issue is to protect the child and safeguard from any further harm. And while that one's the most obvious, we do ask that this court consider it for the remaining children as well, to the extent that they're called. That's going to be on Mr. Amadeo to choose the witnesses that he deemed necessary. But given the nature of the petition, the information that's contained in the court report and the trauma assessments, it seems that none of the children are interested in a relationship with their father, even as it relates to receiving gifts or cards for him, let alone seeing him. So for those reasons, we are asking this court to grant an alternative procedure for witness testimony at trial for the subject minors.
So, Ms. Thomas, if I were to say that it would appear, if I grant the motion, that the most efficient way to move on your request would be to allow the child to testify remotely using Zoom, so that Mr. Lizahu and his client wouldn't have to leave the courtroom, but she would obviously be very much visible to members of the jury at that point without having to see that her father is involved in that proceeding necessarily. Where would your request be for her to testify from?
Your Honor, originally, and I believe I say this at the last pretrial, my only experience in this, and I probably should defer to Mr. Amadeo, but is to set a Zoom up, I suppose, in chambers or in another room within the court, so that if the child did need to be approached for any reason, the child is actually visible. But that would be my preference, but if I may defer to Mr. Amadeo on that point.
Thank you, Judge. May I speak on it briefly?
You may.
Historically, what I've seen done in this situation, to echo what Miss Thomas said, was we would put the child maybe in the jury room or someplace close where we knew sequestration wasn't violated and there was a decent Zoom connection. That way, the preservation of confrontation clause is still in place, but the child does have the protective measures. That's usually done via stipulation, Your Honor. I don't know if Mr. Lyshope's going to stipulate to that, but based on past practice on these cases, that is traditionally how this can be accomplished.
Thank you for that clarification. All right, argument, Mr. Lizahu.
Your Honor, if this court finds that alternative means are necessary, then I would suggest that the child or the children in question sit in the witness box in the courtroom, that I'd be allowed to directly ask questions of the child. I'd be allowed directly to hand those exhibits to the child. And that although I understand the other side wants Mr. Higgins to be outside the courtroom, if he is going to be outside the courtroom, that he communicate with me contemporaneously by electronic means. And I don't see the need for me to be excluded from being able to ask the witnesses directly. And I also believe that all the children need to be advised that Mr. Higgins is viewing their testimony as well. I think that if you take the children and put them in a jury room, that kind of puts up a barrier between the jury and the witness. And it also logistically makes it difficult for me to hand potential exhibits to such witness in another room. So I think for expediency and logistically, and is best that, and following your suggestion last week, Judge, that Mr. Higgins may leave the room, but I think the procedure should continue with witnesses being examined in front of the jury itself.
Your Honor, may I briefly respond to that?
Well, I have some follow-up questions for Mr. Lizahu first, so just hang on a minute.
Thank you.
Okay, Mr. Lizahu, so let me make sure I understand your position. Your primary position is that you oppose the motion and you would like the child to testify in front of the jury as well as with your client in the room. Is that right?
Yes, Your Honor.
Your second choice would be to remove your client from the room?
Yes, Your Honor.
All right. What exhibits do you propose, or do you think you would need to have access to the witness to directly in order to present your case?
There are text messages that were created by the children, which I have shared with counsel, which I believe I would need to present directly to the witness.
How many pages of text messages are you going to be asking the child to look at?
Not many, just a few pages.
Were there text messages in particular that you're going to be asking about?
Yes, I am, Your Honor.
Okay. Is that the only exhibit?
That's the only ones that I plan to hand the witness, correct?
Thank you.
Witness
All
says
right,
more than one witness.
I'm sorry, what?
I'm sorry, more than one witness is the text messages are going to be used on more than one witness.
All right, my understanding is that the child concerned by this particular notice concerns the victim and not, well, okay, is it on all four of the children? Let me clarify that.
It is, Your Honor. And as I stated, specifically for the child victim, but we are including all children.
Your Honor, can I respond to that, please?
Go ahead.
I believe the alternative methods doesn't apply to any child 16 or older. One of the children is over 16 and older.
Okay, I know Mr. Amadeo wanted to respond to something else that he heard. Do you want to respond to that as well as offer your additional comment?
I think they're all going to go run together here, Your Honor. I just want to add for the record, and especially for appellate purposes, this issue has been established in criminal law at preliminary examinations where the stakes are higher as far as burdens of proof. And you do not have a right to have direct confrontation, and Zoom can clearly accomplish this. I just want to raise two other points, Judge, because I am concerned that this could lead to appellate issues as well. These text messages and such, what he wants to do can be accomplished, number one, by providing proper exhibits to your court for review prior to this. Number two, there's going to be authentication problems. There's best evidence rule issues, and more importantly, there's confusion of the issue. And I mean no disrespect by saying this, Your Honor, but some of the things Mr. Lizope has presented, I'm not quite following, and I'm not sure how that's going to be accomplished. I'm not even sure what his solution was here, but the court has been very clear. Mr. Higgins can have confrontation with the child being on Zoom in another room. That's been established. There's no way around that. There's no argument to say that confrontation is not meant. And I don't know what else to say there. It may create more work for Mr. Lies, I hope, but it certainly protects the integrity of the proceedings and more importantly protects appellate rights.
Ms. Berger?
Judge, I think most importantly, it protects the child who has, no matter what, experienced a great trauma in her life. And even if Mr. Lizahoop's argument is found well taken by a jury, having this child be a witness, just like a normal adult witness, is going to cause additional trauma. So no matter what, she's experienced a break in the bond with a relationship with her father that she can't even appropriately address in regular therapy at this point. And I think that forcing her to testify rather in the normal way would increase that and may actually not be favorable to anybody and just cause more trauma. So I would request that she be permitted to testify via Zoom, that any documents that need to be shown to her, I would be more than happy to help with electronically, putting them up on the screen, screen sharing them. That way, whatever device she's using shows right up on her device. That way we can do as much as we possibly can to continue to protect this child.
Well, it would appear that the case would need to be made for each individual child, that the experience of testifying would have an effect, traumatic and significant for each, and it would have to be beyond essentially just the experience itself. So what is your opinion on those pieces, Ms. Berger, as well as the I mean, there is one child, I think, that is over 16, and I would think that this would not necessarily be something we could even offer to that particular witness. What are your thoughts?
I would agree with that, Your Honor. And I don't need testimony from the two younger boys. If they're planning on being called as a witness, then I would request that we provide the same procedures for them. They're triplets, so they're the exact same age. And they're also delicate in their mental state as it relates to the claims. They've been confused, they've questioned both parents, they've questioned what happened, they've tried to talk a little bit about it with their siblings and amongst themselves. And I think that it's a trauma that's happened to this entire family, not just the child that directly experienced it. Now that they are away from it, they're recognizing that some of the things that they saw may not have been appropriate. So I would ask that the protections be engaged for the triplets, and that the oldest child, I don't think that we have the basis to ask for that. And I think he's pretty mature for his age.
Your Honor, may I just make a brief comment?
Sure.
So with all due respect to everyone's opinion and knowledge, and I looked at the bench book on this matter just to ensure that this motion was appropriate. So MRE, so the Model Rule of Evidence 611A, provides that this court has the broad discretion, regardless of age or disability, to allow for these protective measures. And the juvenile code that's cited in the motion is in addition to those powers that are vested in this court. And so both are cited in my motion for those purposes to cover all 4 children. And of course, we leave it to this court's discretion as to whether those protective measures are appropriate for the 4, but there is legal grounds for this court to do so.
Has any professional counselor been directly asked to speak to the issue for the minor children?
No, Your Honor.
Would the department have available to it a professional to do that, whether it's the person that did the trauma assessments or counselors?
Ms. Grant, can you please speak on that?
Are you looking to see if like a counselor can speak for the children at trial, or just if it would be detrimental to their well-being to testify? I guess I'm a little confused.
Well, I'm asking if there's a professional that can look at the issue for the children that are under the age of 16 and identify whether or not it's just the process of testifying, or if not only that, or if it's the father, if we ask him to leave, or frankly, if it would have an extraordinarily harmful effect on them to testify. Because I can appreciate the trauma assessments and the information that I have ahead of me. I just wonder if there is a professional that could be directly asked the question of whether or not the testimony in court in front of the father would be harmful.
It's something I don't have firsthand knowledge to answer that question, but I can definitely explore that to see if we do have somebody. Typically, I know we use Renee Moore a lot for that, but being that the children are in Wayne County, I can always inquire with the therapist who has been working with the family, as well as the assigned worker that, you know, helps with facilitating that kind of thing in Wayne County, to see if they have a program up there that could help us with that.
Thank you. All right, so Ms. Thomas, are you maintaining that the oldest child is not part of the conversation because that child is over the age of 16, or are you asking for interventions on behalf of that child as well?
Your Honor, the motion is for all children under the rules of evidence. But if the court does not find that that's sufficient and we move under the juvenile code, then I would be asking in the alternative for the 3 that are under the age of 16.
Very well. Mr. Lizahood, did you wish to add any further argument?
No, Your Honor. Thank you.
Very well. Thank you. Well, frankly, I would like to see if there is a counselor or professional person that is has more experience and education in the area of mental health treatment than I do, frankly, or any of us do, to weigh in on this question as it relates to whether or not it would be an extraordinary risk of harm to the mental health of the children to have to testify in person. I would like that counselor, if possible, to also speak to whether or not simply appearing by Zoom would be the most appropriate, or if allowing the child into the courtroom and asking Mr. Higgins to step out would be necessary or appropriate as well. So I will defer on the motion and adjourn it, asking the department to secure an expert on that issue. We have a little time before trial. How much time do you need in order to look into that expert?
Your Honor,
Ms. Green?
I was just gonna say, given how backed up all of our service providers are, I would say at least 2 months. Ms. Grant, would you agree with that, or do you think we would have an answer before then?
I can definitely start with the counselor that's been working with them right now. I think that would be a great resources to start there to see if she can give that recommendation and testimony. And then from there, if that's not, I would have to look into it. So I would say at least it could be anywhere from a week if she's able to do it to a month or 2 if I have to look for a different service. Yes.
Well, I have time, April 2nd.
Well, Your Honor,
Schedule
I'm sorry. I'm sorry, Judge. Will Your Honor object if I went to get my calendar?
No, please do.
Okay, thank you.
Ms. Berger, are you available April 2nd at 10:30? If you tried to respond, I didn't hear you.
Sorry, yes, I am.
Okay. So Mr. Lizahu, back to you. I'm suggesting April 2nd at 10:30.
I'm available, Your Honor.
All right, so I'd like to adjourn the motion for that reason. Ms. Thomas, would you mind drafting the order to that effect?
I can do that, Your Honor.
Your Honor, if I get the recommendations back before that time, do you want it before that time, before a court report would be due?
I think that could be useful. Yeah, absolutely. Circulate it at a minimum as soon as you get it to all of the attorneys.
Okay.
I'm satisfied with waiting, but it doesn't matter to me. Probably not less than 7 days ahead of time, if possible, but if you can get it in, then get it in. All right, any other issues for pretrial purposes today?
None, Your Honor. Thank you.
We do have a set of voir dire questions from respondents, proposed jury instructions, and a verdict form, as well as a set of instructions for the jury. So are those the only ones that I'll be receiving?
Yeah, yes, Your Honor. I was going to amend my instructions to change the burden of proof, but yes, those are, aside from the burden of proof issue, those are the ones from we submitted for respondent.
For the department?
Your Honor, yes, the department submitted standard jury instructions that are inclusive of a verdict form for each child. And we also submitted proposed voir dire questions. It was my understanding we were supposed to work as a group to submit one set of those documents, but that did not happen. So that is all that the department will be submitting. And we'll take further guidance from this court on that matter.
There they are. Yes. Okay. I'm sorry. Either they didn't print it or I didn't see that. All I have in front of me as far as what you're representing is the actual stack of papers that starts with the instructions. And then I see now that at the back of that, you do have the verdict form and the questions, but I was unclear on who had submitted those. So thank you for clarifying. All right, Ms. Berger, could we expect anything from you?
I'll have nothing to add, Your Honor.
All right, very good. Any objections to the voir dire questions or the verdict forms or anything else needs to be noticed up? I'll be making final decisions on that as well. Let's set that for the April 2nd hearing. I'll go through these between now and then as well, to determine if there's anything that's so inappropriate that I myself have to weigh in and say no to that particular question. But I would encourage the attorneys to review all of those documents and place anything in writing that you may feel you need to for purposes of objecting to those questions, instructions, or forms between now and April 2nd.
Thank you, Judge.
All right, I believe that's all for this afternoon. It's been noticed to all interested parties that we had a pretrial review today. I do find the department is meeting its obligations for reasonable efforts under the circumstances that Ms. Berger is, well, we didn't actually have a report from you today, Ms. Berger. Did you want to give a report?
I believe I gave one at the hearing a couple of weeks ago.
All right, I do recall that, yes. Any updates?
Nope, nothing to add.
Very good. All right. I do find that she's in satisfaction of her obligations as guardian ad litem, and that the children are in the safest and least restrictive placement with mother, pending the resolution of the initial adjudication and disposition in this case. None of the exhibits that were provided today will be usable at the trial for obvious reasons, and I look forward to further developments on the motion and any other issues on April 2nd. Unless there's any questions, that would be all for today.